Much of the discussion about the Supreme Court's recent Second Amendment cases has focused on the court's use of history, its evaluation of the historical record, the circumstances of the adoption, the debate over the text of, and the early application of the Second Amendment. All of this is appropriate given the originalist thrust of the majority opinion in each of those recent cases, the Heller case and the McDonald case. What I'd like to suggest, though, is that there are maybe other things going on in the opinion that it's worth remembering. I think it's important to keep in mind those other things because they give us a slightly, perhaps more nuanced, but certainly differently directed view of the constitutional interpretation process, which at the end of the day is more than just one group of historians beating up another group of historians and some sort of resolution coming out. I'd like to focus on two elements of the decision. Initially, one has to do with the role of grammar in constitutional interpretation. The other has to do with, more broadly speaking, the approach that the court takes to the interpretation of the Constitution, the various schools of jurisprudence. And I offer these as examples of perhaps alternative directions in which the court could have gone. Now, this is an attempt to advocate for that or against it, but simply to remind that there is some subtlety in the play of the text of a Supreme Court majority opinion when the court's interpreting the Constitution. Now, the grammatical observation has to do with the text of the amendment itself. It, you'll remember, we all know, consists of principally two clauses. One that's characterized in the majority opinion in the Heller case as the prefatory clause, and then another that Justice Scalia calls the operative clause. The prefatory clause is the one that references the militia, a well-regulated militia being necessary to the security of a free state, comma. That's the prefatory clause. The second clause then, the operative clause, so-called operative clause, provides the right of the people to bear arms shall not be infringed. Now, what the majority said in Heller was that those two clauses can essentially be disaggregated, which is to say that the second clause, the operative clause, is the one that the court needs to look at in order to exercise the judicial interpretation function. The first clause, the prefatory clause, is useful perhaps as a suggestion of the sorts of goals that the framers intended to achieve by the adoption of the operational language, but in itself it isn't limiting as to the interpretation of those words. So that it's not one large operational clause. Instead, it's two clauses, one of which is helpful, the other of which is essential. Now, that's an interpretive call, and the court offers historical justification for making that call. But I think it's important to realize that it's theoretically possible that one could have gone the other way on that and interpreted the whole of the amendment as operational. The theory one would have applied presumably would have been some variant of the framers weren't known to waste words. There's not a whole lot of pure guidance provisions in the Constitution, so we choose to interpret the Second Amendment as actually enshrining one comprehensive operational right limited by the language of the prefatory clause. And I think that's the argument that folks who would choose to construe the amendment in a limited manner gravitate towards. So it's all about a militia. It's all about the right to bear arms of members of a militia. And moreover, it's a well-regulated militia, which I think the advocates of this position construe to mean a militia under the express control of public authority. Justice Scalia recognizes the force of this potential argument in several ways. One is at the point at which he suggests that, setting aside the well-regulated part, if the clauses were actually connected, then they might theoretically justify the possession by individuals of weapons suited to modern warfare, which could include anything and everything. In other words, the linking of the clauses would actually effectuate, in that view, an expansion of the scope of the right. And he isn't going to go there. The other point that he makes has to do with the definition of this term well-regulated. It's assumed, I think, by advocates of the linkage position and advocates of the position that the first clause limits the second clause, that well-regulated means, as I suggested, under the express control of public authority. That's sort of how we use those words now and would understand that phrase now. But Justice Scalia makes the point in his majority opinion in Heller that, in fact, at the time, well-regulated simply meant well-trained and competent. And there isn't any explicit connection to public authority. And that's the underscoring of his larger point, that if you tie the two clauses together and you interpret the phrase well-regulated in that way, then you've actually expanded the scope of the right beyond that which was contemplated, he suggests, in the Miller case. And that's the point that I want to return to later. Now, the counter to that position would be is a useful entree to the second major point I want to make, having to do with the schools of jurisprudence. One could respond by saying, well, that may well be what well-regulated meant at the time, but who cares? The world has evolved. The meaning of the Constitution, in a material sense, has evolved. So let's look at well-regulated, the concept of well-regulated as it exists in the early 21st century. Let's accept that phrase in the Second Amendment as being ambiguous, inherently ambiguous, and apply a modern construction to it. And that means that now we do have linked clauses, and they mean what I say they mean, which is to say they mean that the right to bear arms is conditioned on participation in a militia under public authority. And as I say, I think that's sort of where a lot of folks who are on that side of the Second Amendment debate sort of intuitively gravitate towards, or expressly gravitate towards. Now, the second point that raises, though, I mentioned the evolution, arguable evolution in meaning of the term well-regulated. This raises the larger jurisprudential point, which is to say that so much of this debate, virtually all of this debate around the majority opinion, but in public discourse as well, seems to focus on the original intent of the framers of the Second Amendment. And it's not entirely clear that that's the only way that this could be interpreted. Others of the Bill of Rights provisions have been historically interpreted along what we call an evolutive line. Some people call this the living constitution. That's a phrase that appears in reference to the dissenting opinions in the McDonald case. And the jurisprudence works largely as follows. The words of the Constitution are really big. They're susceptible of multiple interpretations. Some say the framers intended that we would then take that as an invitation to interpret those phrases differently over the different generations. Jefferson said that every new generation should essentially rewrite the Constitution to its own purposes and to secure its own values. And so let's look at the Second Amendment in the light of our 21st century reality. That isn't the way the majority went. And it isn't really the focus of a lot of the dissenting response, although it does play a role in the dissents in all of the cases that we're looking at. But it's important, I think, to realize that that's a choice too. The decision as to which jurisprudential school to apply is a call, is a judgment call made by the court. The majority in the Heller case, the McDonald case, went originalist. That's the bent of these individual justices. But there's nothing in the Constitution itself that expressly mandates the application of originalist jurisprudence. So there was an alternative. I might add that distinction between jurisprudential schools plays a key role in the McDonald case. That's the case involving the question as to whether the Second Amendment incorporates into the Due Process Clause of the 14th Amendment, and through that applies to the states to limit the actions in the regulation of firearms of state militias, of state governments. The majority decided that it did incorporate. The dissenting justices argued that it didn't. And part of the grounds for their disagreement was the determination of what the appropriate test was for determining whether a Bill of Rights provision incorporated. The majority, much more driven by our own national historical experience than the dissent. And the way that this dispute played out was in a choice again as to which case to appeal to when determining which rights in the Bill of Rights actually incorporated into the Due Process Clause of the 14th Amendment and applied to the states. It's a subtle but very important difference. The majority decided, or rather we'll start with the dissent decided that the case that should drive that decision was the Palco decision, which included a test for determining whether a right incorporated and applied to limit the actions of state governments that said that the right would incorporate if the right itself were the very essence of a scheme of ordered liberty. So a scheme of ordered liberty effectively relied upon the existence and recognition and enforcement of a particular right. What the majority did was to sort of rewrite that slightly to say, no, actually the test that we want to apply is whether the right that we're talking about is the very essence of our scheme of ordered liberty, our American scheme, and then followed that with a reference to language from the Washington versus Glucksberg case that talked about rights being incorporated if they were deeply rooted in the nation's history and tradition. Once that decision was made, which language to use against which to assess the right, it became much easier for the majority to find that yes, in fact, the Second Amendment right is incorporated because we have all this evidence from the Heller decision that suggests that the framers were all over an individual right to own arms, both for militia service and for self-defense. So two calls made, one having to do with jurisprudence, the other having to do with sort of choices of grammatical construction, and maybe more broadly said, this decision whether to construe the first part of the amendment as limiting of the scope of the right, and the second, and then this interpretation of well regulated.